For parents, clearly one of the concerns that they do have is do they need to go to court to resolve the arrangements for the time that they each spend with their children, or indeed for where the children are living. Our advice is that really for resolving children issues, court has got to be the last resort, and certainly consideration needs to be given to other options available in the first instance. For example, mediation is always a sensible option for parents to attend, to meet with a mediator, to look to resolve the issues that potentially that they've got. And we find that mediation is more often than not successful in resolving those disputes.
If we were to go to court, the court can make several orders under the Children Act Section 8. The main order really is what's called a child arrangements order. So that's basically dictating how often the absent parent should see their child on a weekly basis. The other kind of orders the court can make are things like a prohibited steps order. In those circumstances, it may be to stop somebody from removing a child from the jurisdiction or such like. We can also look at determining which school the children should go to through a specific issue order, and finally where the child should live.
In terms of how the court determines the arrangements for the child, this is determined under the Children Act 1989. The key principle under that is that the child's welfare is the paramount consideration for the court. The court will always make orders that are considered to be in the best interests of the child, and the court has to look at a list of factors under what is known as the welfare checklist, and that will include issues such as whether the child may be exposed to any harm, the capacity of the parents to meet the child's needs, and the ascertainable wishes and feelings of the child, which would only be considered in light of their age and understanding.
As a grandparent, you don't have automatic rights to see your grandchildren in the same way that a parent can make an application to the court. However, in certain circumstances, you can make an application for the court to grant you permission to do so.
We often get asked by parents if they can move abroad with their children, and provided you've got the consent of everyone else with parental responsibility, which tends usually just to be the other parent, then yes, you can freely move out of this jurisdiction. It's not always that straightforward though, and if an agreement can't be reached, then you will need to make an application for the court's permission for you to leave the country permanently. In making that application, you're inviting the court to weigh a number of factors, in particular things like what are the plans for ongoing contact should you relocate abroad? Is your application to move genuine? Do you have a genuine reason to move to another country, or is it simply an opportunity to try and limit the relationship between a child and a non-resident parent? Court will also be very interested in any background research that you've done about where you're intending to move to, and would want to know things like where the child will be schooled, what particular area you might wish to live in, and also in some instances, is there going to be free access to healthcare for that child upon moving abroad. We have an awful lot of experience in dealing with cases involving relocation, and it is important to get advice at a very early stage, because we as advisors will be able to give you a very clear indication as to the prospects of success.
If you feel you'd like to discuss matters further with any of the team at Chadwick Lawrence, please feel free to contact us.